how do you obtain a legal heir certificate in Telangana? Now, there are different procedures for obtaining a legal heir certificate for land and building, and there's a different procedure for obtaining a legal heir certificate for shares in the share market and movable property. In this video, primarily, we will be talking about how to obtain a legal heir certificate for land and buildings. Now, before we talk about how to obtain the legal heir certificate, let's talk about why you would obtain a legal heir certificate. So, take a case where there is a father, mother, brother, and sister. And let's say, due to unfortunate circumstances, the father has passed away, and there is property or there is land or building that stands in the name of the father. Now, in a classic case, what would happen is a purchaser would approach the legal heirs and he would say, I'm interested in buying this property. The legal heirs come to some kind of an understanding commercially as to what should be the price. The prospective purchaser then asks the legal heirs for a sale deed. He sees the sale deed and he says, oh, but look, this is in the name of the deceased father. So why don't you get your names changed in the public record? So thereafter, you approach, say, the MRO, the Mandal Revenue Officer, to get the name changed from the deceased father to the names of the mother, the brother, and the sister. The MRO tells you that, look, I don't have powers to do this unless you're a government employee. So that is the problem that we will be talking about today, and that is the problem to which I will tell you what to do in that kind of a scenario. So your remedy in that kind of a scenario is to file a civil suit to declare all three of you, the mother, the brother, and the sister, as legal heirs to the deceased father. So what you would do is you would go to the civil court where the property is situated, and you will file a civil case asking the court to declare the three of you as the legal heirs. Now, what are some of the documents that you would need to file when you go to the civil court? Well, first you would need to file the Aadhaar cards of all three of the brother, the sister, and the mother, self-attested copies. You would have to file the death certificate of the father. And let's say for a moment that the brother is living abroad, then in that kind of a situation, so the brother stays living in the US, the brother would have to execute a GPA or a power of attorney in favor of somebody who is in India, so that the person in India can represent the brother, and the person in India can represent the brother for these court proceedings. Now, there is a little bit of more procedure there. In that kind of a scenario, the brother would have to execute the GPA or sign the GPA in the US. He would have to visit a notary in the US, get the document notarized, have it sent back to India, and the person in India would have to take that document and go to the office of the district registrar to get the document validated under the Stamp Act. And just a tip, it is always better to give a GPA in favor of a family member, because that way the charges really come down as opposed to giving it to a stranger. So in this case, the brother can give it to the sister or the mother. They can be the agent, and he will be the principal. So those are the three documents, and in addition to these three documents, which is the Aadhaar, death certificate, and the GPA, if living abroad, you would also need the encumbrance certificate of the property, which is the EC. You would have to obtain the market value of the market value certificate of the property. And although the MRO does not have the power, technically speaking, to mutate your names or to incorporate your names into the public record, still formally you would have to file an application before the MRO saying, please change the name from my father's name, or from the deceased father to the mother, sister, and brother. and most likely he's not going to do it. So that's going to be your cause of action. You are going to take that letter and you're going to file it in court, and you're going to say, look, I went to the MRO, he's not doing it. So please declare us as the legal heirs. So moving on, who would be the parties to the case? So the parties to the case would obviously be the mother, brother, and the sister. You would also make the MRO a party who will be represented by the government pleader. Generally they don't have much to say in these cases. And you would also make another party called all concerned. And the all concerned party is so what happens is, so I mean I'll get to that I'll get to that in a second. So what happens is, so let's say the mother will be the plaintiff, the children will be the defendants along with the MRO and all concerned. So the mother would file the plaint, or she would file a complaint in court saying, I went to the MRO, he's not changing it, so please declare me and my children as the owners. The children would also come on record and say the same thing. And at that stage, what would happen is, as I said, all concerned as a party. The stage would, the court will order a publication. So there would be, an ad or whatever that's placed in the newspaper, which would say that, public notice, please take notice that, the mother, brother, and sister are claiming to be the owners of this property. If you have any objection, then, please send your objections. And in the event no objections are received, then the court will proceed and declare you as the legal heirs, or the three of them as the legal heirs, and it will give a judgment or decree to that effect. Now, how long does this take? Generally, it takes about 6 months to for all this to happen. So the sooner the better if you are looking to alienate property. And some of the common mistakes would be, I've been loosely referring to this as a legal heir certificate, but it is not a certificate. It is a court decree that is given out by the court in the event you satisfy, all the criteria that I just talked about. And also, some people may say that you can take an affidavit and get declared as legal heirs. That will not work. Your only remedy in such a situation is to approach a civil court and get yourselves declared as the legal heirs. I hope you enjoyed the video. Thank you for watching.